Welcome everyone to this presentation on the Singapore Chamber of Maritime Arbitration's 4th edition rules. My name is Lawrence Tay and I am the chairman of the SCMA's Promotion Committee. We do have a very interesting presentation lined up for you today that will cover not only the rules themselves, but the background to the rules and what motivated the changes in the rules such as we find them in the 4th edition today. The first order of business is for me to call upon Punit Oza, the Executive Director of SCMA, to give an overview of the 4th edition to the SCMA rules. Punit would be known to all, and without any need for further introduction, Punit, will you take us through the background and an overview to the rules? Punit?
Thank you so much, Lawrence, and thanks for all of you tuning into this webinar. And thanks so much for all the panelists to come and join us today as well. I think the new SCMA rules are great, not just good, but great. And I don't say this because I'm the executive director of SCMA. Good rules would have been those which kept up with times, but great rules are the ones which keep up with times, but go beyond that. We have attempted to create a new set of rules which are simple to understand, easy to use, fit for purpose, and cater for the future as much as it is possible to do so. I'm sure the esteemed panelists will elaborate on all these aspects and more, but in our mind at the Secretariat, the new rules serve the following objectives. They promote clarity and order. They are responsive and future-proof SCMA as much as possible. They ensure user-friendliness. They aim to be cost-effective. They support the self-administered model and promote party autonomy and give wider discretion to the tribunal. They emphasize the finality and speed of arbitration. They generate basic data to improve and innovate, a critical building block for the future of SCMA. And finally, they provide guidance with practice notes and model clauses. None of this would have been possible without the amazing efforts of all of you, the public, who participated and contributed in the first fully electronic public consultation exercise. Following that, I have to sincerely thank each and every member of the SCMA Procedure Committee, especially Chairman Andrew Moran, who's present here today with us. A huge thanks to the board members of SCMA who polished and debated on the new rules and came up with valuable suggestions. And finally, a sincere and deep appreciation to Damien, our legal manager and assistant registrar, for his hard work, in-depth knowledge, and dedication. This is an amazing result of real hard work and efforts. Post that exercise, I want to thank the rest of my team at the Secretariat, SCMA Promotion Committee, headed by Lawrence, who's present here, SCMA Local User Council members, 2 of whom are also present here, and all other members of the community who have warmly received, supported, and commented on those rules since their release. The real satisfaction will be when these rules are used by the parties and they achieve the objectives that we wished for. I look forward to a great session that follows as we go along. Thank you, Lawrence.
Thank you very much, Punit. Now, ladies and gentlemen and members of SCMA, your procedure committee has been hard at work for an extended period of time, beginning with initial consultations and then deeper consultations, ending up today with the 4th edition of the SCMA rules. So as to give you an idea of the depth and the breadth of the consultation, I'm going to call upon Chairman of the SCMA Procedure Committee, Mr. Andrew Moran, QC, to talk about the motivation going into first the review of the SCMA rules, 3rd edition, as well as what was done in and about the revision of the rules. Andrew, would you tell us a little bit about the work that your procedure committee has been doing? You're on mute, Andrew.
Can everybody hear me now?
Yes.
Yes, good. So you're right to begin with, Lawrence, that it has been a long-running process, interrupted by COVID, like everything else. I begin with apologies to those present who have heard me speak on this subject before, recount this history, but it is important for me to recount some history and background to set the new rules in context for you all. If we begin with the expectations of maritime parties in arbitrating their disputes, I think everyone will agree that they have been conditioned by hundreds of years of experience of maritime arbitration as conducted elsewhere other than Singapore, particularly in London, New York, Paris, and I always add in, for reasons which those who know me understand, Liverpool. I won't argue the case now, but I will simply say the Liverpool cotton traders had a very big hand in formulating the way in which we resolve maritime disputes since the time of the American Civil War and the blockade of the southern ports of the USA, leading to a raft of disputes that the courts in London simply could not cope with, and thus they set up their own arbitration association. So as Singapore and Hong Kong, other centers now for maritime arbitration, continue to develop as seats and centers for maritime arbitration, expectations of parties are more nuanced and changing. Here, they're influenced by direct participation of Chinese, Indian, ASEAN parties, some with a different civil law background and approach to dispute resolution. So the form, use, and application of the SCMA rules in Singapore must remain sensitive to and understanding of these different expectations as they develop. Now, the SCMA began its existence as part of SIAC, offering maritime arbitration under the first edition of its rules in an institutional format. It was not in accordance with the long-established traditional approach and parties' expectations for ad hoc dispute resolution with these features, conducted in accordance with light touch rules and procedures, designed for parties to follow for themselves with minimal arbitrator involvement and thus minimal arbitral costs up to the point of determination of the dispute. Thus, you can understand why it was that the institutional format was not well received by the industry. It was recognized here in Singapore, and thus there came about the hiving off from SIAC and establishment of the SCMA as a distinct chamber for maritime arbitration, following traditional non-institutional procedures. With that change came the second edition of the SCMA rules in 2009, and these unashamedly catered for what the predominant maritime parties of the time wanted, and that was rules similar to the LMAA terms with which they were familiar and comfortable. So the second edition of the rules were thus designed to facilitate the adoption of traditional practices in maritime dispute resolution, but were necessarily adapted for a model law seat and to conform with the International Arbitration Act, which applies here in Singapore. The third edition of the rules in 2015 represented the next step in the development of the rules, although the changes from the 2009 rules were reactive to correct perceived deficiencies and sought to respond to user and potential user needs and requests. There was nothing like the extensive surveying and canvassing of views and opinions and the wishes of such users that might use SCMA arbitration, as has occurred with this latest version of the rules, as I shall shortly explain to you. So these new rules, at the 4th edition, reflective of that process, which I'm about to explain, will form the framework, as Punit has explained, for maritime arbitration in Singapore in the years to come. And thus it is important to explain, as I did as long ago as the 17th of June 2020, that's how long things have been going on and this task has been proceeding. I explained then, at a time when we were launching a wide-ranging consultation, which has been mentioned by Punit and Lawrence, how the process was undertaken. I explained that the review of the rules and the consultation was not about reinventing the wheel, but about development and progression of a tried and trusted form of arbitration for maritime cases, capable of the widest use possible in different kinds of maritime case to make it more efficient, responsive, and user-friendly wherever possible. And the whole process began with the setting up by the former chairman of the SCMA, now sadly deceased, my good friend Goh Jun Seng, with a wholly new procedure committee under my chairmanship, with its first and principal task being to undertake a review of the rules leading to the consultation that was then being launched. I explained then, and do now, what Jun Seng's brief was in the approach to this process, which now has come to fruition. First of all, in relation to the formation of my committee, he was determined to assemble the widest possible membership in terms of all of the following: maritime specialisms, practicing location, nationality, global industry representation, particularly with 2 senior P&I Club directors as members of the committee, and thus representation of and by the widest possible constituencies of actual and potential users of SCMA arbitration. We had representation of interests and all types of maritime specialisms coming from London in the west and spanning the globe through Singapore to the eastern maritime hubs of China, and as I say, everywhere else in between. And the object was to gather from the personal experience and connections of all of the committee members ideas for improvement, reports of dissatisfaction or suboptimal experiences with SCMA arbitration. The members of the committee, I can tell you candidly, the way we did it, they all produced independently a written report to me detailing the concerns and ideas that they had become aware of or had experienced for themselves in dealing with the 3rd edition of the rules. And it became clear upon coordinating those reports what areas of improvement were necessary. And it was an excellent basis for us to start with. Then came the consultation. I won't speak any more about that. It was a productive and helpful effort, honing the ideas that we brought into the drafting. There was then a detailed and lengthy drafting process undertaken. And as Punit has recorded, the way that worked was that a draft version of the rules, the final draft from the procedure committee, was submitted to the board of the SCMA, and it was moderated by the board with very helpful ideas coming forward, resulting in some modifications and the finished product, which you now see before you and hopefully will come to use in due course. Inevitably, in the result of all of that, it will be observed that the new rules have included practices and procedures already found well used and established in LMA arbitration. No doubt we will be accused of plagiarism, but it can honestly be stated that the new fourth edition of the rules, the SCMA rules, is not the product of copying, but as I have explained, and this is why it was important for me to explain, it is the result of a carefully planned investigation into what users and potential users wanted to see in the rules, how they wanted their disputes in maritime affairs resolved. And indeed, that is why I will not be pontificating now about these rules in what follows, but instead it is the representatives of users largely who will now tell you how they will work. And I will hand over now to them. Thank you.
Thank you very much, Andrew. Ladies and gentlemen, the time that we have today will not allow an exhaustive explication of every single rule in the fourth edition. What we have done is to select discrete topics which we think would be of interest to you, particularly those that have experienced changes, and formed a panel to which I will put questions, and you will see from the answers given to them an illustration of how they work in practice. The areas that we will cover would be appointment of arbitrators, hearings and awards, arbitral procedures, and finances. I'm going to introduce members of the panel now, and they are members of the SCMA and work within the framework of the SCMA, contributing their valuable time, which they volunteer freely. The first is Mr. Karnan Tirupati. He's a member of the SCMA Procedure Committee. Karnan is a partner with Kennedy's Legal Solutions, and he specializes in arbitration in the commodities, shipping, and marine insurance sectors. Next is Nicholas Fell, who is Head of Corporate Services and General Counsel. Nick holds responsibilities for the legal, insurance, corporate secretarial departments. He is a member of the SCMA Local Users Council. And last but not least is Ms. Tan Wan Jing, also a member of the SCMA Local Users Council. She is a senior lawyer in GUARD, one of the largest P&I clubs among the international groups. She's based in Singapore and handles both claims and defenses. Can I call upon them to put on their cameras now as we go into a discussion? Right. The first area, as I mentioned in our presentation today, deals with the appointment of arbitrators. And those of you who have a copy of the rules in front of you, we are going to speak in particular about Rule 8 and 8.4. The fourth edition of the rules maintains the position that parties are free to agree the number of arbitrators and the procedure for appointment. It also maintains the position that if the parties do not agree the number of arbitrators, there will be 3 arbitrators. Wanjing, would you like to tell us what happens under the rules if the arbitration agreement does not specify the procedure for appointing arbitrators?
Thank you, Lawrence. So under the current 4th edition of the rules, as is normal, the claimant will appoint 1 arbitrator when it serves its notice of arbitration. The respondent will then appoint their arbitrator when they serve the response to the notice of arbitration. So the interesting part is that unless expressly agreed otherwise, the 2 appointed arbitrators will actually constitute the tribunal, and the arbitration will then proceed with 2 arbitrators for the time being. So the 3rd arbitrator, by default, will then be appointed and may be appointed at any time before any substantive hearing, or if the two appointed arbitrators cannot agree on any matter relating to the arbitrators.
Karen, for some of our users, particularly those not familiar with London maritime arbitration, the two arbitrator process might need some explication, might need some clarity. How do you see the two arbitrator process working in practice? If you were to sit down with someone who knows very little about that process, how would you explain it to them?
Okay, thanks, Lawrence, for that question. As you alluded to, for those of us who are familiar with the LMAA arbitrations, this is something we may already be familiar with dealing. What I would say is, basically the situation is we've got a 3 arbitrator default process. So 3 is the default number of arbitrators. But as Wan Ching pointed out, the tribunal is already constituted once the first 2 are appointed. So 1 is by the claimant, 1 is by the respondent. And then the arbitration actually can go on from that point with 2 arbitrators without the 3rd arbitrator being appointed yet, right? So you'd actually have a savings in time, right? Because you don't actually need to appoint the 3rd arbitrator until later on. And there's also some cost savings as well, because the 3rd arbitrator may, if nothing unusual happens, or if no preliminary applications are made, or on preliminary issues and so forth are made, the arbitration could actually go on with 2 arbitrators all the way to the end where you've got a hearing, right? So in the interim, the 2 arbitrators are appointed, receive the submissions, they give directions and so forth. And as Wan Ching pointed out, what happens is the need for the 3rd arbitrator comes into play either if the 2 arbitrators can't agree on anything, then you need a 3rd arbitrator appointed to be the tiebreaker, or if you are going for a substantive hearing, right? So the reason why you need the 3rd arbitrator appointed before the substantive hearing is because you need to ensure that there is a tiebreaker arbitrator already who's going to be attending that hearing. Otherwise, if you proceeded with a substantive hearing with 2 arbitrators, and there's a deadlock, then what do you do? You'd actually have to go back to have a rehearing. So I think just to wrap up on that, the one practical point I think to remember is that that if you are going to have a substantive hearing and no 3rd arbitrator has been appointed yet, parties should actually prompt the tribunal to do that.
Great, some very useful advice. Turning now to Rules 8.1 and Rule 44, we see for the first time the introduction of a procedure known as expedited procedure. Now, this may or may not be similar to the small claims procedure in the 3rd edition, but it is a change of which everyone, ladies and gentlemen, should be aware. I'm going to ask Nick Fell how similar or different the expedited procedure is compared to the small claims procedure, and whether this is something that the parties need to opt into, or whether it's something that will apply automatically. Nick?
Thank you. Yes, I will address that, but I would like to actually start from a user's perspective by reinforcing a couple of things that Lawrence, you've said, and also Andrew and Punit. And that is that this is a tremendous leap forward for the SCMA. And that's not just my opinion. Actually, over the last few weeks, I've received, I suppose, 7 or 8 law firm briefings on the new rules over my desk, including one this morning, which I thought was summed it up rather well when they said, these are the 4th edition, and they said this 4th time is the charm. And they were talking about the implications for maritime and international trade arbitrations in Singapore. And they ended the briefing by saying the changes show clear steps to further streamline and modernize the arbitration process under the SCMA rules, strengthening the efficiency, fairness, and certainty of future arbitrations. And all the briefings that I've read, every single one of them, I couldn't find a single negative comment, all very positive about the rule changes. And I think that is what most users or all users of the SCMA will think, including myself and the company I work for, BW. Anyway, back to the actual question on the expedited procedure. And I think the first big difference between the expedited procedure and the former small claims procedure is in the title. So the emphasis is not necessarily on the quantum of the claim at stake, but the expedited nature and how quickly this can be done. It's a change in the title, but it's a difference in orientation, and I think that will very much please users. But of course, not ignoring the actual quantum, the quantum is now leapt from 150,000 US dollars to 300,000 US dollars, excluding things like interest and costs. So in my sector, in shipping, that's extremely welcome because quick, efficient, cheap proceedings are what we want, and we don't want to go through necessarily a full-blown arbitration for simple claims. And so this increase to 300,000 is most welcome. And it's also automatic, actually, if your claim is in that range, or that amount or less, unless you agree otherwise. And there's also an interesting flip, and I would urge users to consider this, that you can, of course, agree to use this expedited procedure, no longer called small claims. You can agree to use this for any amount, actually. So I think companies like mine would like to see is that we voluntarily agree to amounts that are higher than 300,000, where this excellent procedure can end up determining claims swiftly. And one of the substantive differences is there is a sole arbitrator, unless folks agree otherwise. And if the two parties in dispute can't agree to that sole arbitrator, then the chairperson of the SCMA for the time being, or whoever he or she delegates, will pick. The rule 44, that is the rule that governs this expedited procedure, also encourages summary determination. So quick, simple determination, and it actually permits the tribunal to proceed without an oral hearing, and to limit what we all know can be a very cumbersome disclosure process in common law systems to the most relevant areas. And the overall effect, I'm confident, will be an increase in the efficiency, speed, and reduction in costs for users like ourselves. Thank you.
Great. Well, Nick, while we have you, I'm going to go now to the next area of the fourth edition, which deals with hearings and an award. Of course, time and cost implications are very important for those in shipping, not just for ship owners, but for everyone. And one of the significant changes in the fourth edition is to the element of hearings in SCMA proceedings. This is significant enough to be an important area for our discussion. Would you like to tell us what has happened in the fourth edition vis-a-vis hearings in SCMA proceedings?
Yes, I would. And under the previous third edition, previous situation, the rule was that the tribunal must, no option, hold a hearing unless the parties agreed to a documents-only determination. So that was mandatory. And as everyone knows, holding a hearing is it can be quite an arduous thing, getting everyone together and so on. So now the situation's changed, and the tribunal itself can decide if it needs an oral hearing. That's the default. This is rather similar to the London LMAA situation, where many shipping disputes in particular are decided on the documents only. You don't need a hearing. However, it is provided that if one party, either party decides, no, we want an oral hearing, then that will happen. But I'm hopeful that in the kind of smaller or less fact and law intensive disputes, that parties will be sensible and will opt for document-only hearings, dispensing with oral hearings. Of course, if you do go for an oral hearing, it can be remote these days. It's been very, very successful, proven during this pandemic that oral hearings work rather well remotely. Or the provision provides that the tribunal can hold the hearing, if it goes down that route, in any manner it deems appropriate. So a welcome development there, and hopefully we'll see more simpler disputes without hearings and done on the documents only.
One thing, the novice to international arbitration or to maritime arbitration might assume that in every set of arbitration proceedings, there is an absolute right to a physical hearing. Nick has addressed that concern to some extent, in the sense that he said that as long as one of the parties insists that there should be a hearing, even under the fourth edition, there will be a hearing. But perhaps we could explore some other areas of efficiency with the new rules as to whether a hearing will take place. From the point of view of your own experience, do you see areas in which efficiency in SCMA arbitral proceedings would be increased with the new approach to hearings?
Yes, Lawrence, I think the short answer to that is it would. So as Nick pointed out, the two main changes to the rules on hearing right now are A, the arbitrators now have the discretion to decide whether or not a hearing should be held, or if the matter should proceed on a documents-only basis. And the second one is that virtual hearings are now a formal option under the new rules. Now, on the first, to give the arbitrators discretion in deciding whether or not a hearing is necessary just means that proceedings which are more suited to be determined on a documents-only basis will now be conducted as such. So as an example that I can think of, a speed and performance dispute is going to be largely based on the performance reports, weather data, and it's clearly a dispute which should actually be conducted on a documents-only basis. So a lot of time and cost can actually be saved from avoiding unnecessary hearings, which Nick pointed out earlier. So as a user, as a P&I club, we want to make sure that the cost incurred, the time involved is actually going to be proportionate to the dispute at hand. And knowing that a tribunal has the discretion to decide that such a hearing should take place on a documents-only basis is actually very assuring for a P&I club, I find. But of course, as pointed out earlier, should a party request a hearing, the tribunal will definitely order that a hearing take place. Now, moving on to virtual hearings, which is made popular thanks to COVID, and now a formal option under the new rules, I find that very welcome because it also means that parties can now save on traveling time and costs. So what I have actually attended recently is an arbitration at the end of last year where we've got counsel attending from London, we've got an arbitrator attending from London, and everyone can actually just make it work depending on the hours in London and Singapore. And you know, there wasn't extensive traveling time involved. We don't have to pay accommodation fees. It's just time costs and the transcribers costs. And I find that fantastic, to be honest, as a P&I club, looking at the kind of costs to be incurred for any dispute that I should support my members on.
Great. Well, we have you, Wan Ching. I'm just going to ask you an additional question. Do you think that users will use this new rule as to there being hearings only at the discretion of the tribunal to perhaps approach the tribunal to say there can be hearing for some of the more important things, and for some of the other things, we don't necessarily need to have a hearing. It could be something as simple as the difference between liability and assessment of damages, for example. But do you think that would encourage or start a kind of practice where people approach the tribunal?
I think so. I mean, I think at the end of the day, when we want to go for arbitration, we are looking for flexibility. And if, you know, there are if you've got an arbitration with various disputes and various points at hand, and there are some which can be proceeded on a documents-only basis, but if you've got differing testimonies such that you need to be able to cross-examine the witness, then obviously a hearing should take place. But if there's going to be, say, a discrete point of law which should be determined before you look at the facts, then that would actually help users a lot in deciding how best to allow this proceeding to proceed in as efficient a way as possible, cost effectively as well, I think.
Great. Kanan, the rules say that if a party without sufficient cause fails to appear at a hearing, the tribunal may proceed with the arbitration and make an award. How do you envisage this unfolding in practice based on your own experience and based on your understanding of the rules?
Okay. When the procedures committee met, I think one of the concerns that we were trying to address, a major concern, I think, was what do you do in a situation where you've got an unresponsive respondent or a respondent who's just dragging his feet and trying to make things difficult and delay, right? So this new rule, which is Rule 25.4, was one of the rules, I think, that was put forward to address that point. So it's actually to just set out explicitly that the tribunal does have the power to proceed to make an award, even in situations where the respondent who's being difficult doesn't appear in the hearing, right? But the thing is, balancing that power, you've got to take into consideration issues of whether the arbitration proceedings are being conducted fairly, and so I think the thing built into this is that you do actually have to give the respondent the opportunity, right, and sufficient notice and all that before you exercise this rule. But I think at least it makes it clear that the tribunal can do so. So in practice, what we'd be looking at is you've got a respondent who's just keeping quiet or coming out with excuses or asking for lots of extensions of time and so forth. What we'd have is the tribunal giving a clear notice, of the intention to have a hearing, so that the respondent cannot later say that he didn't receive the notice or didn't understand it. You'd also be having the notice giving the respondent reasonable time, right, to make arrangements to attend the hearing. And also you'd probably be looking at the tribunal also giving the respondent the opportunity to comment in advance, to say that these are the dates I can make it and so forth, or these are the restrictions that I've got. I just add here, I think a point that Wan Ching mentioned just now as well, and you also, I think, Rule 25.3, I think Nick mentioned it as well, makes it, gives the tribunal the power also to ensure that hearings can take place in other modes, right? Video conferencing, telephone hearings are referred to expressly. So this gives the respondent even less excuse not to turn up for a hearing, right? So what we'd be seeing at the end of it is, the tribunal, if it does give the respondent the opportunity and the respondent does not turn up, the tribunal can proceed to issue the award. In the award, I think the tribunal would be recording what attempts were made and so forth. And then, under this rule, therefore, the tribunal is proceeding to its award. I think at the back of everyone's minds, or maybe more to the fore even, the claimant, I think, would be looking to ensure that the award is enforceable, right? So I think this rule helps that happen. But if there are, I think the practical tip here, I think, is that if the claimant feels that his award is going to be enforced in a particular country, then and that country has specific requirements that the tribunal may not be aware of, the claimant should actually raise those with the tribunal so that the tribunal can accommodate that.
One of the issues that has come up in relation to hearings, whether they are physical hearings or virtual hearings, is that parties from some countries or some jurisdictions may actually say that they don't have proper access to electronic virtual hearing facilities. We all take it for granted if one is in a developed country, and we assume that there will be Wi-Fi, there will be connectivity, but there may be occasions where a party simply says convincingly and credibly that they don't have sufficient access to virtual hearing facilities. I suppose one of the reactions that Wan Jing and you would have would be that the concept of a hearing doesn't necessarily include a real-time hearing or a visual hearing or indeed anything that requires sound to be heard. But I thought perhaps you could share your thoughts on that as well, and the difference between a truly recalcitrant party and a party who cannot attend a hearing.
Yeah, I think that's the thing about this rule. I mean, there is a qualifier that, the part, it says in the event that the party to the proceedings without sufficient cause fails to appear. The thing is, I think all of that has to be taken into account. I think it is, my own experience is that it is rare for someone not to be even able to do a hearing by telephone, for instance, or it could be timing issues and so forth that need to come into play. But I think if the tribunal gives the party options and the opportunity to participate in the hearing, and none of those are taken up, and nothing is offered instead, there's no suggestion from the respondent forthcoming as to how else the hearing should proceed. We can't just leave the proceedings at an end there, right? So I think a solution has to be found, and the tribunal has the power to make the necessary orders and to order a hearing in a way that accommodates parties as best possible.
Thank you. I'm going to invite a comment from Andrew Morand. Andrew?
Yes, I think it's worthwhile mentioning that there was much debate in the committee as to whether Rule 25.1 should end with a full stop after only. So the rule would be the tribunal shall decide if a hearing should be held, or if the matter is to proceed on documents only, full stop. And the part that came afterwards and is in the rules now say that there shall in any event be a hearing so long as any party requests one. It should be explained that drafting arbitration rules in Singapore under the International Arbitration Act, which incorporates the model law and gives it the force of law in Singapore, Article 24 of the model law has that requirement, which comes after the comma in the present rule. Now, I recognize, and it's been the subject of much debate and legal deliberation, judicial deliberation, that parties can agree to opt out of that right and could have done so under these rules. We could have done so in drafting the rules so that people did agree to opt out of that Article 24 right to require a hearing. But in the course of our consultations, going back to vaunt the worthwhile nature of the consultations that were undertaken, our researchers and feedback did indicate to us a number of instances in the jurisdictions proximate to Singapore where Singapore awards fall to be enforced, that even where there is a power in the arbitrators to proceed without affording the parties a hearing by rule or arbitration agreement, awards were not enforceable. We found one even in that friendly and arbitration-friendly jurisdiction, India, in the High Court, in a High Court case in India, where an award, enforcement of an award was refused, and we found several in Vietnam and Thailand. So this was a hotly debated issue, but we did not feel that we could stop this rule after the word only. It was too dangerous. That was the collective view, and that is why the rule is in the form it is.
Thank you, Andrew. Ladies and gentlemen, let's go now to the question of settlement. Another significant change in the fourth edition, and I'm referring in particular to Rule 39.4, is that it now sets out a procedure by which tribunals can take into account settlement offers. Again, offers to settle can sometimes terminate proceedings, and if they are terminated early enough, can result in substantial savings in time and costs. I'm going to call on Nick again to explain how and when a party who has made a settlement offer can make this known to the tribunal, but not allow the terms of the settlement to color the mind of the tribunal. Nick?
Thank you, Lawrence. I think you'll have noticed by now that one of the features of the rules is that they encourage or they discourage parties that don't want to participate in the arbitration from getting their way. Certainly at the beginning, in terms of appointments and how the swiftly the procedure and the serving of statements and so on is meant to go. And then this is at the back end where a settlement offer may have been made and what the tribunal's powers are in relation to deterring parties from not accepting a reasonable offer. And actually it goes beyond that. It goes to mediation as well. If a party has unreasonably refused an offer of mediation, then the rule 39.4 says, hey, we can take that into account in an award of costs. So if you're a participant, I would recommend considering mediation as the way out. And if you don't, be warned, the tribunal can take that into account in a costs award. And absolutely the same with settlement. The tribunal can look at the settlement offer and say a party has unreasonably refused it, and then penalize, if you like, the party that has refused by way of costs. Any party can, up to the time when the final award is made, so that could certainly be after the oral hearing or after the submissions have been looked at, say, hey, there was a settlement offer, here it is, and then the tribunal can decide to take a look at it and determine whether the party that refused should bear some penalty by way of costs. And disclosure of the settlement and its terms are at the discretion of the tribunal.
Presumably, Nick, you would also say that this rule would be applicable even where there is an ARB-MET-ARB procedure that the parties have agreed to. They've halted the arbitration to go to mediation. They are unable to find a settlement through mediation, and they return back to the tribunal for an award. Once the award is established, and on the question of costs, presumably you would say that what transpired in mediation might reasonably be informed to the tribunal for the purpose of their assessment on cost allocation.
I'm not sure about that, because if a party has, in good faith, if both parties have participated in the mediation, which is confidential and should not be revealed, the actual discussions in the mediation should not be revealed to the arbitration tribunal, which of course is constituted of different people not related to the mediator. So those discussions in the mediation are totally private. What the rule aims to do is say, if you've refused to even participate in mediation, then you can be penalized. Not that if you haven't come to a successful mediation, you can be penalized. So that's a bit different.
Yeah.
Does that answer the question, Lawrence?
Yes. I suppose the takeaway from that is that a party who wants to remove doubt about the admissibility of what has gone on in mediation and wants to use a settlement offer in relation to costs, should issue a separate settlement offer after mediation has failed, and then perhaps that can then be informed to the tribunal.
Exactly. So the settlement offer, if you failed in mediation, if a party wants to put the other side at risk of costs, should definitely make a separate settlement offer, separate from the failed mediation. Yes, that's right.
Great, thank you. Ladies and gentlemen, let's go to arbitral procedures now, and I'm referring in particular to Rule 4.4. If you have read the fourth edition, you would know that it now provides that any change by a party to its authorized representative is subject to the tribunal's approval, and the approval may be withheld. Now, this is an interesting change to the rules, which we thought was very worthy of discussion. And I'm going to start off by asking Wan Jing, in what sorts of situations would a tribunal withhold a change of representation, and on what basis? Wan Jing?
Thank you, Lawrence. I have to admit that this is actually one of my favorite updates of the SCMA rules. I agree with Nick that the main updates to the rules really are meant to encourage parties to participate responsibly and in good faith in the arbitration process. And the intention, obviously, is to discourage recalcitrant parties from getting away with their tactics and strategies in derailing proceedings. So here, where there is a substantial risk that the change of counsel may prejudice the conduct of the proceedings or could affect the enforceability of the award at the end of the day, that the tribunal may withhold approval for a request to change counsel. So I have seen that there have been instances where a counsel or lawyer has been changed just before a hearing, and a request is made for the hearing to be postponed so that the newly appointed lawyer can get up to speed on the file. So oftentimes for an international arbitration, we are looking at schedules of 3 arbitrators, various lawyers across the globe, various representatives across the globe, and that could actually result in a delay of several months. So with this new rule, I find that, and I hope that disingenuous attempts to derail proceedings by requesting a change of counsel at the last minute could be rejected by the tribunal. So some feedback that I have actually received and heard on the ground is that arbitration proceedings are no longer nearly as efficient as they are purported to be and how they once were. And the main complaint really is that a lot of time can be wasted by a recalcitrant party. So as Kanan and as Nick have alluded to earlier, there are parties who do not want to participate, or they are constantly asking for time extensions, or they ask for hearings when there is no need for a hearing. And in this case, where they change lawyers at the last minute simply to delay proceedings. So I have seen charter parties where parties have actually opted for court proceedings instead, because attempts to waste time, including this attempt to derail proceedings, are less likely to be entertained and are very likely to be frowned upon by the judges. So this update is quite welcome in my books, at least, and I would hopefully put a stop to such disingenuous attempts by any recalcitrant party in the SCMA proceeding.
Did you have a view, Wan Jing, as to how a tribunal might be able to discern whether a request for change of party representation is genuine or reasonable, and when it is disingenuous and a derailment tactic?
Yeah, so I have thought about it. I think it must depend very much on the basis for this request. You could think that, okay, as matters proceeded, you thought, okay, this other counsel would have been a better choice for you. And then it depends very much on what sort of delay we're looking at as well. So if this is going to be the party's 3rd or 4th attempt to change the counsel, and it's a series of attempts to basically delay proceedings and to be disingenuous, I think that shows a pattern, and that would certainly assist the tribunal in deciding that, hey, this is not something that is a genuine attempt to get proper representation.
Thank you. So, very important to choose the right tribunal members who can who have enough experience to look at a situation objectively.
I think so. And I think more importantly is that the rules actually give the tribunal the formal authority to do so. And that is something that really, really assists, I think, all parties involved in an arbitration proceeding.
Going now to the seat of arbitration, SCMA arbitrations, and to rules 31 and 32, I'm going to ask Karnan whether it is possible for the parties to choose a seat of arbitration other than Singapore under the 4th edition, and if so, what laws would apply to a non-Singaporean seat? We know about selection of juridical seats under the 3rd edition, but Karnan, can you take us through the current state in the 4th edition?
Okay, where the relevant rule is Rule 32, right, which is in relation to seat of arbitration. So it's specified, it sets out that the seat of arbitration shall be Singapore unless otherwise agreed by parties. And where the seat of the arbitration is Singapore, the IAA shall apply unless otherwise agreed by parties. So built into Rule 32 is a default setting, right, where if the contract or arbitration agreement does not specify the seat is taken to be Singapore, and then therefore also the IAA would apply. So what, though, I mean, it's significant is the words unless otherwise agreed by parties. So this, accommodates an arrangement whereby the SCMA rules could apply, but the seat that parties agree to could be any other country. So it could be, for instance, an SCMA arbitration with a seat in Hong Kong, for example. So if that were the case, the SCMA rules would apply, but the underlying procedural laws would be the laws of the seat, which would be the Hong Kong law. So in that case, it'd be their arbitration ordinance. So that's how it would work. So I think the SCMA rules are default position. It's Singapore seat, Singapore procedural law. But if parties agree to use the SCMA rules in some other seat, then the SCMA rules will still apply, but the underlying arbitration laws in that country would also apply. I think for practical purposes, one of the points would be, for example, if you're doing a challenge to an arbitration award, which courts should you go to? What rights of challenge you have, and who has jurisdiction? Those sorts of things will come to play depending on what seat you choose.
So if parties want a different review procedure on the arbitral award, they must take care to select the seat that they want expressly. Otherwise, if I understand you correctly, the default position would be that Singapore is the seat.
Yes, correct. Yeah.
I'm going to ask Nick now about his views, and perhaps to touch a little bit upon the appeal on points of law structure in England, not from any technical or detailed point of view, but how that may or may not make a difference between Singapore and English-seated SCMA arbitrations.
Yes, thank you. And this is quite relevant as a user as well. What we often find in our contracts is that English law is chosen as a substantive law, but we're quite keen on having SCMA or Singapore as the seat. But if you choose Singapore or having the arbitration in Singapore, but I think most people on this call probably know that appeals are very, very difficult in Singapore, very difficult indeed. Whereas in England, whilst there aren't that many appeals actually from arbitration that get through the screen, some do. And some parties really enjoy having the theoretical and practical right of an appeal should they hate the arbitration award. That does happen, obviously, particularly if you're the losing party. And in that case, you may choose to have SCMA rules apply, but you will have English law applying as the seat. But the seat, most people know, but just to reiterate the basis, doesn't mean the physical hearing has to be in England. The physical hearing can be here in Singapore and quite often is. It's just that English law will govern the procedural matters that Kanan talked about, including this right of appeal. So that is why we often see SCMA arbitration physically to be held in Singapore, but with English law as the seat. It depends which side of the fence you're on. And of course, retrospectively, if you lose, you might wish that you'd picked English law as the seat. But since we can't see into the future, a lot of commercial people are very happy to not have the right of appeal. Others would prefer the right of appeal. If you're one of those people, then at the moment at least, recommend picking English law, but still sticking with SCMA.
Thank you, Nick.
Lawrence, could I make a point on this? Sorry to interrupt you, but
yes, go ahead, Andrew.
I think it's important that I should flag this up with people, for people not familiar with the whole arbitration regime in Singapore. First point, which may be known to many, is that there has been extensive consideration in Singapore as to whether in the International Arbitration Act, the English restricted ability to appeal should be imported. And that would mark a significant change to the philosophy of final outcome that Nick has just been alluding to. When we were drafting the rules, there was much consideration given to whether we ought to prompt in the rules by some means the availability for parties to choose to apply the Arbitration Act in Singapore, which does afford a restricted right of appeal. There's no restriction on doing so. Parties can agree that that act will apply rather than the International Arbitration Act, so that parties can choose to have a right of appeal in this seat if they choose to apply that particular act. But when we were drafting the rules, we thought it was perhaps a little bit rich for one arbitration association or chamber to lead the way in relation to rights of appeal, to change the philosophy that Singapore has adopted of not having the limited right of appeal that the Arbitration Act 1996 provides in arbitration seated in England. So a little bit of background to why the rule is in the form that it is.
Well, can I ask you, Andrew, to on that topic, to offer an opinion or a view as to whether you see the Arbitration Act leave to appeal procedure in any way that is different to the procedure and the prospects of getting through on an appeal in England. Do you see major structural, philosophical differences, or is it really the same thing?
I don't see any fundamental differences. It's essentially the same philosophy behind it, that it is a very restricted avenue to appeal, which you will only pass along if you have a very clear case that an error has been made, which is obviously, as we all know, the case with Section 69.
Thank you. The final area that we would like to explore in this afternoon's presentation is broadly termed as finances, but really has to do with tribunals' fees and expenses. The fourth edition, and in particular Rule 40, introduces the standard terms of appointment. This is new to the SCMA rules, and I'm going to ask Wan Jing whether she can tell us what they are and whether they apply to all SCMA arbitrations. Wan Jing?
Thank you, Lawrence. As you pointed out, the standard terms of appointment actually deals with issues on the appointment of the arbitrator, and they include, independence and impartiality of the arbitrator, exclusion of liability, indemnity, and right down to the administrative areas such as arbitrators' fees, appointment fee, travel time, cancellation fees, travel expenses, liability for the same. It also provides for security and basis on which it should be provided for the arbitrator's fees, either to be held by the SCMA or some other approved money holding arrangement. So unless agreed otherwise, these standard terms will apply to all arbitration carried out under the 4th edition of the rules. And the default terms are now public knowledge and easily accessible by everyone. So they would also form a very good benchmark when looking at, terms of appointment for other arbitrators.
And what did you think of the more express and pronounced standards by which arbitrators are to be held as set out in the standard terms of appointment?
I personally welcome it. I think it's very clear. It gives a lot of clarity. And I personally have not seen or have not encountered a situation where, detailed negotiation are carried out prior to us appointing the arbitrator. But this serves actually as a very good benchmark to what to look out for. So for example, looking at the rules itself, the terms of appointment, it actually talked about, what sort of travel expenses, if incurred, should be payable to the arbitrator. And they are talking about, what sort of airfare, airport transfer, and that I find very welcoming, because it gives you the breakdown and the details required to just know what sort of costs are you actually looking at when you have, say, a physical hearing, if that's going to take place, now that we can actually have virtual hearings as well. And that's I find that a very welcome change, very refreshing for me, very transparent.
Great. Nick, did you have a view on the standard terms of appointment, particularly since you dealt with expedited procedure earlier today?
Well, all I would say is I think that they're welcome, because they take out a lot of the angst around the initial negotiations with the arbitrators on fees. So you've got the fixed fee element, which just makes things. Certainty is one of the things we look for in arbitration. So this takes out one of the uncertainties, I suppose, is the succinct way of answering that.
Yeah, and I suppose you would say a lot of transparency comes with published standard terms.
Yeah, and actually not only transparency, but I think it's pretty competitive.
Thank you. Now, every tribunal would turn its mind at some stage to asking security for its fees and expenses. And like the 3rd edition, the 4th edition deals with security for tribunals' fees and expenses, but with some changes. Karan, can you tell us how these provisions are different and how they operate practically?
Okay, thank you. So the 3rd and 4th editions both had rules relating to tribunal security for costs. So in the 3rd edition, it was Rule 13. Here it's Rule 41. I think what's significant is echoing what Nick and Wanjing said about standard terms. It's actually promotes greater transparency also in this new 4th edition. The 4th edition comes together with a practice direction 2, which gives guidance to the tribunals on how, what request for security should be made and what information should be provided to parties. So I think it's helpful here that under the 4th edition and with the practice direction, the guidance given to the tribunal provides that the tribunal should provide a breakdown of anticipated hours and rates, right? So parties actually know when the security demand request is being made, that it is in fact reasonable and is in line with what the dispute is about and how much time is going to be spent in the case. And I think also the other significant point here is that it's also been made clearer now with this practice direction that the tribunal shouldn't be asking for all its security for costs at the outset for all the costs it's going to be incurring up to the end of the arbitration. So the guidance to the tribunal now is for security deposits to be requested in stages, right? So you've got 3 stages in the proceedings. You've got from the appointment of the tribunal up to questionnaire. So that's when all the written submissions are in. Then the second stage is disclosure and evidence, and then after that, the final stage is actually the stage where you're going for a hearing, and then you're going to have the tribunal drafting its award. So it needs cost covered for that. So I think it helps parties as well, right? Because you've got you don't have to pay up all the security at the outset. I think it leaves room for parties to take settlement also, into consideration. I mean, it'll be on top of their minds as well. Like, you would put up security for a certain stage, and then perhaps you could settle at that point, and then you close the case. Or if you are moving on to the next stage, then you have it's again drawn to your attention that these are the tribunal's costs going forward to the next stage. So I think that all helps. It procedurally it helps, and I think it helps people, helps focus minds, and it's also, I think, above all, provides a greater transparency in terms of what the arbitrator's costs are.
Yes. One of the things that occurred to me when I read Rule 41 and Practice Note 2 in the way that you've described is that this could actually encourage budgeting, not just budgeting in terms of tribunals' fees and expenses, but it might also be the starting point to encourage cost budgeting on the side of parties, and perhaps also the start of an appreciation as to what the tribunal would regard to be reasonable costs incurred by the winning party that it could recover from the losing party. Do you have a view on this, Khaled?
Yeah, I agree with you. I think the budgeting aspect of arbitrations are so important, right? The clients always want to know how much it's going to cost, right? And having the tribunal provide its fees and costs in this sort of a manner, when they're asking for security for costs, also will make parties themselves question their own lawyers' fees, and like what is my own budget for proceeding, through to the next stage. Yeah.
Great. Now, ladies and gentlemen, we have set aside some time for question and answer, and we encourage you to use the question and answer facility to pose your questions. While you are thinking about the questions that you would like to pose to the panel, I'm going to invite our Executive Director, Mr. Punit Oza, to talk about some particular aspects of the rule, and he's very keen to show you how a big picture may be made up of smaller ones. Punit?
Thank you so much, Lawrence. And I must say that it's so nice, and I'm very happy to see the kind of discussions and the points being highlighted. I think the procedure committee and everybody involved with the rules would be really happy to see the kind of discussions that just happened. I would be doing a great injustice to both the Secretariat, Damien, as well as to the procedure committee if I don't highlight some of the minor, small details which actually are incredibly useful for parties. The first thing is the index of the rules. We have, for the first time, introduced an index of rules. The rules are structured in parts. There's a flow to the rules. There's a very helpful right-hand tab in the rules, which you can know where you are, which part of the rules you're in. And obviously, the rules have been made gender neutral, which is also very important from a perspective of future-proofing the rules. Another thing that we have done is we have taken out all the monetary sums out of the rules. So as and when we update the schedule of fees for any reasons, those can be updated independent of the rules, because previously if we had to update the fees, for example, for any reason or include new fee structures, it would have then the whole new rules would have to be drafted, or there would be major amendments to be done. Now we've taken that out. So that's one of the things to remember. There's a very interesting Rule 27 about deemed closure of proceedings. Again, to highlight the same point about proceedings being dragged by parties, especially disruptive aspects. So obviously the deemed closure of proceedings is something which is hopefully going to be very useful for the parties. Minor, small details which actually help a lot. And the last point that I would like to mention is about data. Please do have a look at the reporting requirements. They are not mandatory. They don't prejudice your case in any way, but they would help the SCMA a lot. So please do have a look at it and try and comply with them if possible. And that would be really, really useful for SCMA. One final comment as a user, because I've been in the shipping industry for many years, on the expedited procedure, I can only say that it has happened so many times in my experience that I have left money on the table because I was not sure how much would the arbitration cost, how long would it last, and what would be the potential cost involved. The expedited procedure actually helps in clarifying and creating certainty so that a party can evaluate that $300,000 is on the table. This is what it's going to probably cost me in terms of arbitration cost or legally recoverable cost. And then you certainly have the ability to actually judge and make sure you don't leave money on the table for claims which require you to go through with arbitration with certainty and finality. So these are the only few comments from my side, but I really, really enjoyed the discussions and the conversations. I think we are so happy to see things going in the direction where we want to them to be headed. So thank you so much for everybody. Lawrence, all yours.
One question that has crossed my mind has to do with the SCMA questionnaire. Again, those who are not so familiar with maritime arbitration would not necessarily have heard of an SCMA questionnaire, yet questionnaires are in frequent use in maritime arbitrations around the world. What I would like to do is to pose to the various members of the panel, starting with Andrew Moran, what they think of the questionnaire, what they think its use is to date in SCMA arbitrations and maritime arbitrations generally, and whether they see the practice of using questionnaires to continue. In essence, whether it's still a useful thing or something that might evolve as we go along. So, Andrew, would you like to lead us?
Yes, this was a very important part of our consideration, and everyone will see that the am I muted? Yes. Everyone will see that it has been beefed up. And let me just take an example on an issue that we were just discussing, which you raised, whether the standard terms of appointment and the focus on the costs of the arbitration might encourage parties to budget through the various phases of an arbitration. And what we've done in the questionnaire, a series of questions at the end of it, do interrogate the parties as to what costs have been incurred and what future costs are likely to be incurred, which will focus minds. Certainly, we thought it would focus minds. The other thing that I should say about the questionnaire, indeed the whole process of maritime arbitration, the questionnaire is a very important tool in or for restricting arbitral costs, getting the arbitrators involved and incurring their charges. Because you will see in the heading of the questionnaire, which is very, very important, it enjoins the parties to engage together, to agree everything that they can agree. So if there is going to be a hearing, the objective is that the arbitrators are not really involved, need not really be involved from the moment of their appointment until the time they come to determine the issues, whether on documents alone or at a hearing. And the whole scheme of the changes to the rules is to go back to less and less involvement of arbitrators and parties engaging together sensibly and constructively to get to the determination by whatever means is appropriate in the particular case with least money spent. You're mute, Lawrence.
Wan Jing, thank you, Andrew. Wan Jing, from the point of view of a P&I club, or indeed from your own personal experience, how do you view questionnaires? Do you think they're very useful, somewhat useful, not useful at all? Tell us about it.
I don't think I can put it as eloquently as Andrew did, but I agree with him wholeheartedly that it really does focus parties. So it basically allows, well, at least from P&I Club perspective, it makes everyone sit down, consider the submissions, the arguments that have been put out, and it then makes you narrow down the issues and look at the costs involved. And I think that's a very important point, which Andrew pointed out. What are the costs involved? What are the chances of success? And how does that actually weigh in the long run? Is this an arbitration that should actually proceed and continue? Because the next steps are going to be, I think, you're going to look at, hearing, that's going to be a big cost. You're going to like expert reports, witness statements. These are all big costs that will have to be incurred thereafter. So what I find useful about questionnaire is that it basically forces parties to look at the main issues that needs to be discussed. It basically forces parties to look at the costs that's going to be incurred, and it will make the club and the member evaluate the chances of success and weigh it accordingly. So it's very useful for me.
Lawrence, if I could also add, and I agree with everything that's been said by Wang Jen and Andrew, is I enjoy the nudge at the end, question 12, the last question on mediation, which gives another impetus for that mode of dispute resolution. Does the party consider that the case is suitable for mediation? First question, has mediation been proposed or rejected? And the very final question, does the party seek a pause in the procedural steps for the possibility of mediation? So a good plug and nudge for mediation at the end of the questionnaire.
Yes. Thank you, Nick. Perhaps I can ask both yourself and Wan Jing what you think of the thought that arbitral tribunals should actively inquire of the parties as to the prospects of exploring settlement and the prospects of achieving settlement. Do you think that's something the tribunal should be proactive about, or should the tribunal be inert and allow the parties to simply read the rules, read the questionnaire, and decide for themselves whether to go into settlement negotiations?
Because I'm a lawyer, I'd say it depends, but I am a fan of mediation because I've seen it practically succeed nearly every time. So anything that can encourage it in tandem with arbitration, I'm a fan of. So yes.
I do agree with Nick. The clubs also like to, if there's a chance for settlement, I think that parties should seriously consider that. Mediation is a great option. I guess there has got to be a balance between self-administered arbitration and the tribunal pushing parties too hard in that aspect. So what I do see is that if two parties are commercial parties with, same intention to settle, settlement could actually be broached. And, if there is a party who is not particularly interested in discussing settlement, then any attempts by the other party to do so would not result in any fruition. So maybe that's when perhaps the tribunal can say, hey, look, the questionnaire said that it's been proposed and rejected. How many times? This is something that parties should actually seriously consider. And yeah, I think that could be interesting.
Great. Kannan,
Lawrence, sorry, just to add on that point, just a quick point. I think, my view, lawyer in practice, is that perhaps you don't necessarily want the arbitrator to take a very proactive role in trying to get the dispute settled, but prompts are fine. And I think this paragraph 12 about mediation, I think the important thing is actually it's part of the discussion that the lawyer needs to have with his client, and a serious one, about why we are not doing mediation and why prospects are not good, and that's why we're going ahead. Are there other reasons and so forth? I think it's important that we have this paragraph 12 so that it allows that sort of discussion to be had between the client and the lawyer.
Yeah. I was going to ask you, Kanan, to consider that there may be a significant number of counsel in maritime arbitrations who treat a questionnaire simply as something to just fill up and get it over with. How can we encourage a more meaningful addressing of the questionnaire to counsel, such that the tribunal would also equally pay attention to the answers in the questionnaire, and the questionnaire ending up serving the purpose that it was intended under the rules? Did you have any particular experience with an opposing counsel who might not have taken the questionnaire seriously?
Yeah, I have had those sorts of experiences. I think I think you and I share the view that it is important. The questionnaires are important, and they help focus minds and allow parties to understand actually just zoom in on what the issues are in dispute are, I mean, primarily. I have seen cases where, like you have said, lawyers go through the motions and they're still holding back and trying to withhold information, you know, and be hazy and fuzzy about the position. I think, I mean, my view is these sorts of things should be taken into account in when addressing costs, right? At the end of the arbitration. I mean, that's one of the things I think that should be taken into consideration. Were all sorts of unnecessary issues kept in reserve when actually they could have been closed down earlier, or you know, is a particular party just again trying to be difficult and delay and so forth, and that's why they're not actually setting things out properly. So I think cost is one of the cost awards, like at the end of the arbitration, is one of the ways of dealing with it.
Thank you. Can I invite Andrew and then for any last comments they may have generally about the 4th edition of the SCMA rules, whether it relates to any of the areas we have traversed today or generally. Andrew?
Yeah, just one comment that perhaps I should have mentioned when we were dealing with it. That is the rule which allows a tribunal to refuse consent, as it were, for a party to change its representation. The big issue and difficulty here is, of course, privilege. The difficulty of a tribunal inquiring into why a particular lawyer wants to withdraw or the client wants to be rid of the particular lawyer. I remember when I was a young barrister, in all sorts of cases, you used to be able to get away with standing up before the judge and say, "My lord, I'm in professional difficulties," and you would withdraw. You'd be allowed to withdraw, and the case would be adjourned, and that would be the end of the matter. Well, that is very much a thing of the past. We recognize that this will involve some tiptoeing through the tulips by a tribunal. And all I would say to all of those listening, and arbitrators particularly amongst them, you will have to be very careful when you are considering employing this rule to make sure that the proceedings continue. But don't be over timorous, especially in an arbitration. I encountered this sitting as a judge as well. But in arbitration, I think we can be more robust and investigate within proper limits, not breaching privilege. And with experience, you get a pretty clear view of whether this is tactical or genuine issues of conflict arising. I think that's the only thing I'd want to add to all the useful comments that have been made by the panel on the various rules.
Yes, and I suppose part of what you say about not needing to be overly timorous also brings to mind the fact that duties in arbitration, representations, they're all owed to both sides. So whilst one might be very careful or too careful, one might actually doing an injustice to the other side who is facing these long delays.
Yeah, absolutely. So it's a balance, as in all things.
Punit, did you have any final comments?
I just wanted to remind the audience and all of us that basically some of the other procedures, specialized ones like the Singapore bunker claims procedures, the ARB protocol and procedure, and CDOC for the collision claims are still very much a part of the SCMA offerings. So they are very much a part of the new rules, and they have basically got their utility as well. So please do have a look at that. The idea behind this is, as Tradewinds nicely captioned it, is to create a do-it-yourself arbitration guide. And I think we have succeeded in a considerable manner of managing that, as I see. So thank you so much for that. I have no further comments to this, Lawrence. Thank you so much.
Ladies and gentlemen, thank you very much for joining us today in our presentation on the 4th edition of the SCMA rules. All of us here at SCMA commend the rules to you and ask you to consider using the SCMA rules in your contracts. Have a look at the rules. I think you will find that they're very interesting, they're very innovative, and they will help you in your business, particularly in terms of management of time and costs. So with that, and on that note, I bid you all a very good day.